The topic of today, Italian intellectual property appeal, is declaratory judgment actions. It is common opinion that declaratory judgment actions may help the alleged infringer to preempt actions of the IP right owner based on IP rights. In fact, it is more difficult to obtain preliminary injunctions granted when DJ actions are pending. Declaratory judgment proceedings are commenced serving a writ of summons on the defendant. The date of the first hearing is decided by the plaintiff. The plaintiff, however, has to give 90 days, at least 90 days, to the defendant to base its defense. And this term becomes 150 days if the defendant is resident abroad. Within 10 days from the date of the service, the plaintiff shall file with court the writ of summons served and the file with all the documents. At that point, the case is officially filed with court and take a docket number. Therefore, the case is pending. The defendant has the possibility to file its defensive brief until the date of the first hearing. If the defendant wants to file counterclaims or have third parties to join the proceedings, he needs to file its defensive brief 20 days before the date of the hearing. The first hearing is a direction hearing. The judge will verify if the writ has been properly served on the defendant and will grant 3 deadlines. The first deadline is 30 days after the hearing, is to file a modified version of the statement of claim or of the statement of defense. The second deadline, it's other 30 days after the first deadline, is very, very important because it's the deadline for the filing of evidence. After this deadline, no more evidence can be filed with court unless a technical examination is ordered. The third deadline is the deadline to file reply to the evidence filed by the other party, and is of 20 days after the second deadline. At that point, there is a discussion hearing. The discussion will regard the evidence that has been filed by the parties and the necessity to take further evidence, meaning to hear witnesses or to appoint a court expert. If no further evidence is needed, or in any event, when all the evidence has been collected, the court schedules a final hearing. Again, it is a direction hearing, and from that hearing, there is a deadline of 60 days for the parties to file their defensive briefs. The final defensive briefs are the most important documents in the case, are the documents based on which the case will be decided. Then the parties may have 20 days after the first deadline to file replies to the final defensive brief filed by the other party. Normally there is no oral discussion. However, at the final hearing, the party may request to discuss orally, and in this case, there will be only the final defensive brief, not the reply. The oral discussion will replace the written reply. The case is decided by a panel of 3 judges. Normally, the decision take place within 60 days from the date of the final hearing or from the date of the filing of the replies of the parties. In Italy, intellectual property proceedings last around 1 year and a half or 2 years after the first hearing. It may take a little more in patent case because there is a technical examination to be carried out. The Italian IP appeals are based on lived experience. The LA Piper is one of the few international law firm with a strong IP litigation team in Italy. Stay connected to know more.